After the promulgation of the decision on the 11th of March, we roughly know how the framework is going to be formulated. And so we've already started to look at what sort of, which legislations are going to be amended. So we started looking at the overall framework. But of course, we have to wait for the Standing Committee's amendments to Annexes 1 and Annex 2 of the Basic Law before we can complete our work. The team within the Department of Justice primarily, of course, is the law drafting division, but we also need lawyers who are familiar with the electoral systems and the basic law and the various other areas of law, and they will be called upon to give legal advice as well as to provide assistance to the drafting. The lead bureau, or the policy bureau, I should say, is CMAB, and of course CMAB will then provide the policy instructions to tell us what aspects of the law we're going to have to amend, and there will be, once we have those instructions, we're going to make those changes. Well, that's a clear manifestation of double standards on the part of the United States. They amend their laws in order to deal with the electoral systems to suit the actual situation that happened there. And when the central authorities do that for Hong Kong, they say all sorts of things which is totally uncalled for. One must bear in mind that the democratic electoral systems of any country is a matter that is entirely within the purview of the central authorities and an exercise of the sovereign right of that particular country. The NPC has the power and duty to ensure that the Constitution is being observed and the systems in Hong Kong is being implemented. And that's exactly what the United States is doing for themselves. And when China does it, they make all these uncalled for comments is absolutely unfair. And to even use this as an argument, as an excuse to impose sanctions on our officials is, with respect, a violation of international law. That should not be something that any civilized state should do. We in Hong Kong would want to use the best of our strengths in the legal sector, and I would call it a deal-making and dispute resolution expertise to further the 14th five-year plan as well as the 2035 vision that is part of the national policy. I think the expertise that Hong Kong has in the common law, being the only jurisdiction within China that uses common law, provides a very good platform for commercial businesses to use and to choose Hong Kong as the substantive law that governs their commercial transactions. So I think we can utilize our strengths in this particular area, marrying up the financial strength as well as the legal strength. When we talk about dispute resolution, we also need to, we must understand that we have a very strong system, both in terms of the court system, which is the litigation, as well as other dispute resolution methods like arbitration and mediation. And of course, one very important feature is that Hong Kong is the only jurisdiction that can allow parties to an arbitration to apply for interim measures in the mainland courts when the arbitration is seated in Hong Kong. We have been providing training for investment mediation for government officials from a number of countries, as well as for mediators and practitioners here in Hong Kong. So we've got a very strong foundation for all types of dispute resolution mechanism.